Is there something in your past that might disqualify you from getting a green card? Have you been told that you might never get a green card because of something the government says that you did? We've helped thousands of immigrants solve similar problems by using our 953 method. In prior videos, we discussed what the 9 is, the 9 principal paths to legal status. Think of them as doors. And the 5 most common disqualifiers for achieving legal status. Think of these as locks. If you have one of these 5 problems or locks, this video is for you. In this final video for the 953 process, we're going to discuss the 3 best keys to open those locked doors of your past so that you can get your green card. Keep watching this video to discover these valuable keys that can change your life. I invite you to subscribe to our channel, activate notifications to receive updates on our future videos. I also invite you to stay till the end of the video while I reveal an important announcement. So, let's get started. Imagine you made a mistake in your past or have a legal issue that would normally prevent you from obtaining a visa or a green card. A waiver is a request to tell immigration authorities, I know I made a mistake, but here are the reasons why you should allow me to stay or should allow me to return anyway. So the first of the 3 keys, number 1, is waiver. Now there are many different types of waivers depending on your specific situation. Figuring out the right waiver is really difficult without the help of a knowledgeable immigration attorney, like the green card attorney. A waiver is an opportunity to explain why you deserve a second chance despite the problems in your past. Let me give you an example. Maria entered the United States illegally to work for a few years, but she never left. Now, years later, she married a U.S. citizen, and they have a 3-year-old child born inside the United States, so the child is also a U.S. citizen. Now, Maria is seeking to obtain her green card, but her illegal entry makes her ineligible. In fact, Maria was told several times that she could do nothing because she's only going to get deported. Now, Maria is aware of the problem, but she's desperate to stay with her husband and child, so she set up a green card planning session with Andresmejerlaw, the green card attorney. At the appointment, Maria was taught that she can apply for a waiver. In this waiver, Maria outlines her family situation, emphasizing the strong relationship she has with her husband and child, who depend on her, and arguing that deportation would separate her from her family and cause extreme hardship to her husband specifically. It's not that their child doesn't count, but under the terms of the statute, waiver is really focused on a spouse or parent who's a U.S. citizen or lawful permanent resident, and in this case, it's her husband. Now, when the waiver is granted, Maria will be eligible for a green card. In the past 20 years, I have met way too many people like Maria who are eligible for a green card, have a path, but were given the wrong advice. They had doors closed in front of them that they could have unlocked if they only knew. A waiver is an alternative to overcome obstacles in the process of obtaining legal status in the United States. It allows people like you in situations similar to Maria's to present their case and argue why they deserve a second chance. So if you're like Maria, and you too deserve a second chance, but don't worry, if your case doesn't resemble Maria's, maybe your problem isn't an illegal entry, maybe you committed a crime in the past, maybe you applied for something and were denied, or maybe you have a health-related problem like you have not been vaccinated for COVID. There are many different waivers. If you think you need a waiver, give us a call or leave a comment below and we'll help you understand your situation. Let's talk about the second key, motion to reopen. So what is a motion to reopen? Remember, in a prior video, we discussed how an order of removal would disqualify you. If you don't remember, an order of removal is a deportation order, but the law changed in 1997. Deportation obviously made too much sense, so Congress changed it to deportation from removal. Okay, it's all practical purposes the same thing. It's a different procedure to get there. Well, that order of removal that you may have gotten could have been issued by an immigration judge, or in some circumstances, It could have been issued by an immigration agency like Customs and Border Patrol or Immigration and Customs Enforcement. A motion to reopen is a request for the judge or the agency to eliminate the order of removal. It is used when there are new circumstances, a change in facts, or a change in law, or procedural errors that were not considered in the original decision. The purpose of this request is to provide a fair opportunity to correct possible injustices or wrong decisions. Let me give you an example. Let's talk about Carlos's situation to better understand what is a motion to reopen. Carlos is an immigrant living in the United States for many, many years. Carlos was married 3 times to 3 different U.S. citizens. Each of his wives filed a green card application for him. The first one was in Chicago, the second was in New York City, and the third in New Jersey. The case in New York was very delayed after an initial interview. It took years. It took so long, in fact, that Carlos got divorced, moved to New Jersey, married his new wife, and his new wife filed an application for him providing a New Jersey address. When that application was filed, you got it, Carlos gave a New Jersey address. However, the New York office denied his second green card application, put him into removal, but they didn't mail the notice to his New Jersey address that they had. Instead, they mailed it to a New York address where he had not been living for years. In fact, there was a Monday, Carlos had an interviewer, and the immigration officer in New Jersey gave him his green card, not physically, but approved his application, and his green card was sent in the mail. The very next week, the New York Immigration Court gave him an order of removal when he failed to show up for a court appearance that he didn't even know of. Years later, Carlos files for U.S. citizenship, which was denied because of the order of removal in New York, and he comes to us. So we filed a motion to reopen in New York Immigration Court. After years of waiting, because COVID happened, the judge reopened the case and eliminated the order of removal. The judge then moved the case to New Jersey, since that is where he was then living. Then, of course, it took a while for a judge to get appointed, and then we had to go to court. And ultimately, the removal proceedings were terminated, and Carlos can now file to become a U.S. citizen because the order of removal was removed. Now here, the mistake was actually the government. It's almost absurd that he had to go through this time, energy, and expense to fix the government's mistake. But unfortunately, sometimes that does happen. Now remember that there are solutions for many obstacles. If your situation is the same as Carlos, fantastic. But your situation might not be the same. Maybe you have an order of removal because you didn't appear to court. Maybe you were apprehended at the border and they gave you an order of removal and you then later returned. Depending on your situation, give us a call, leave a comment below. We'll set up a green card planning session to evaluate your specific options. You can always call the number or leave a comment for us to get back to you, or just view some more of our videos. Just don't forget, ask for help. Now let's talk about the third and final key to open your path to your green card. Number 3 is reopen criminal convictions. Now, there's 50 different states. That means 50 different penal statutes, which also might mean 50 different names for reopening criminal conviction. In New Jersey, it's called post-conviction relief. In other states, it's called a motion to vacate. But whatever the term is, the point is to reopen a criminal conviction, just like we reopened an immigration proceeding through a motion to reopen. Same basic idea. This key gives you the possibility to reopen a criminal case that has been decided against you. Maybe you pled guilty, maybe you had a trial. This is often many years after the time to appeal has already passed. The purpose of reopening a criminal conviction is to correct a legal error or injustice. For example, let's say you were convicted of a DUI, that's driving under the influence of drugs or alcohol, and it is later discovered that one of the officers was using a breath machine with falsified information. You may not know this, but there are 20,000 DUI convictions in the state of New Jersey that are in question because Officer Dennis was discovered to have falsified documentation about the Alcotest machine. That means every one of those 20,000 convictions now, maybe none of them should have been convicted. They all have to be reevaluated. Maybe you make your case go away. Also in New York, it was decided that, this is a different example, right? But in New York, it was decided that the criminal definition for possession of cocaine is broader than the federal statute. That means there are people who were convicted of possessing cocaine in the state of New York that under federal law would not have been convicted for possession of cocaine. Immigration purposes is under federal law. So whenever there's a conviction, even in the state, immigration will look at it from the prism of how would federal law evaluate that. For people that were convicted of cocaine possession in the state of New York, those convictions can now be reopened potentially. In both circumstances, the conviction under federal law and the state, a conviction can be reopened and limited, and that would unlock the door that was closed by the initial conviction. But these are just two of many examples. The outcome of reopening these cases could result in a modification of a criminal sentence, maybe annulment of the conviction, dismiss of an unjust conviction, or it might be amended, modified into something else, ideally something that doesn't have immigration consequences. To provide you with a clearer understanding of how reopening criminal conviction works, let's talk about Juan. Juan's an immigrant who had lived in the United States for several years, was convicted of possessing marijuana with the intent to distribute, possession of marijuana, and possession of drug paraphernalia, resisting arrest, and eluding the police. So he was charged with all of these crimes. He had an attorney, but they really didn't discuss about immigration consequences. Juan pled guilty to possession of marijuana with intent to distribute, and the other charges went away. So he pled guilty to the most significant crime with the worst consequences, and the lesser offenses were dismissed. Because of that conviction, he was put into removal, and he can now be deported because possession with intent to distribute is considered drug trafficking, which is an aggravated felony under federal law. Years later, Juan is married to a U.S. citizen and has 3 kids. He comes to a green card planning session. We order all of his criminal background to determine what his options are. Applying the 953 method, Juan's wife can file for his green card. So he has a family-based application. He has one of the 9. Now, we look at his background and see what disqualifies him. That's the 5. He has an aggravated felony. Waiver can't help with that felony because it's, under immigration law, it's an aggravated felony. So reopening the conviction for possession with intent to distribute, and changing it to something like possession of marijuana under 30 grams, well, that's a big deal. That's massive. Why? If you're convicted of possession of marijuana, you can be deported unless you have a U.S. citizen spouse who's filing for you, in which case there's an exception for 1 conviction for possession of marijuana under 30 grams. That's what we did. We filed a post-conviction relief motion. We went back to court. We were able to reopen it. Once we reopened it, we were able to amend the offense to something that didn't have immigration consequences, like possession of marijuana under 30 grams. Why is that important? Well, not every state says 30 grams, right? In New Jersey, conviction is 50 grams. But for immigration, it has to be under 30 because that's what the federal rules require. So in that case, he was just convicted of possessing marijuana without any indication of the quantity. There was no documentation that was in the record that would allow immigration to say, this person is not qualified because he had too much. Nothing there. All there is possession alone. Charges went away. Today, Juan is a green card holder, even after 4 other attorneys told him it was impossible. So far, I've explained to you 3 important keys to unlock closed doors that could prevent you from getting a green card. It's worth mentioning it's much easier and cheaper to avoid having a door closed in your face. So if you're facing criminal charges or are in removal proceedings, get your green card planning session right away. Let's find an easier way to get it done right the first time. If Juan had the right advice before he pled guilty, he would have saved years and thousands of dollars. Don't make the same mistake. Before we conclude today's video, let me remind you of the 3 keys I showed you today to overcome obstacles on your path to legal status. The first is your second chance, a waiver. Number 2 is a motion to reopen to get rid of an order of removal entered by a judge or an immigration agency. And number 3, post-conviction relief or reopen criminal convictions to avoid immigration consequences. We've reached the end of today's video. This was the last step of the 953 method, which I've been teaching you in recent videos. If you haven't watched them, I encourage you to review them so you can understand the entire method and have the necessary tools to obtain your legal status in the United States. I enjoy giving knowledge to people about how to attain legal status, so I'm going to give you a free copy of my book, 9 Ways to Obtain Legal Status in the United States. It's available on Amazon for $29.95, but by visiting our website, which I'll leave in the description below, you can get a copy completely free mailed to you if you live in the United States. Also, you can order your green card planning session valued at $495. If you let them know you watched this video, the green card planning session will be absolutely free for you. We won't charge you unless we can help you. I hope this video, as well as the 953 method, has been helpful to you. I invite you to share this content with anyone you think can be of assistance. See you in the next video. Espero que te gustó el video. Te invito a que veas otros videos donde te comparto más consejos para cuidar tu reputación como inmigrante. Hasta la próxima. Gracias, mis amigos.